The question which is often asked to me, whether the SARFAESI Act will override the MSME Act. I tell everyone, there is no question of whether the SARFAESI Act overriding the MSME Act. The whole question is, the SARFAESI Act is a special law enacted by the Parliament to enable banks to recover monies due to in an expeditious way. MSME Act is also a special law. MSME Act is enacted to protect it's a preventive legislation. It is a remedial legislation. It's a welfare legislation. It's a benevolent legislation. The whole purpose is to protect the MSME from dying, and to, when it is in sickness, to render its nursing and care. So it is a preventive legislation to prevent the MSMEs from falling sick, and where a remedial, if it has fallen sick, to protect it. And therefore, the Parliament enacted this law, realizing that MSMEs are the lifeline of the economy. It provides the largest number employment to the largest number of people, and therefore it has to be given all priority. And then we believe in a socialist egalitarian concept. So the MSMEs, there are how many lakhs of MSMEs in these countries. So unlike the big industrial entities, the MSMEs involve the lives of thousands, lakhs and lakhs of people, so entrepreneurs and workers. So it has to be protected. Now recently the question whether MSME Act will, SARFAESI Act will prevail over the MSME Act has had relevance, because recently 2 judgments came from the Kerala High Court. In both cases I appealed, and the Kerala High Court took the view that MSME Act is only, the protection under the MSME Act is only an optional one. The banks are under no obligation to extend it, and the bank can at its option extend it. The borrower at its option can apply for it. If the borrower has not applied for it, and where the bank has not opted to extend it, then it cannot be enforced. So the Kerala High Court judgment is, with utmost respect, I beg to say this, absolutely, it practically renders the MSME Act and the notification dated 29/5/2015 redundant. Now the saving grace is that the similar question came before the Bombay High Court. A batch of matters, around some 50 cases are there. It was elaborately heard, and it was adjourned for pronouncement of orders as early as on 8th of August, but no orders have been passed. It is pending. Then another batch of materials, another batch of cases, where the protection of which I sought was far wider. There my contention was that the protection under the MSME Act and the notification dated 29/5/2015 is not confined to banks and financial institutions. It will cover all for protection against all sorts of recovery. The case in hand was my client took money from the Siemens Finance for the purchase of machinery, and my contention was, if machinery is allowed to be taken away for non-payment of the rent. So machinery was lease. It's actually a credit only, but lending only, but they term it as a lease. So accept that it's a lease. For non-payment of the lease rent, then if the machinery is allowed to be taken, then the industry will die, and the whole purpose of the MSME Act is lost. So my contention is, the protection under the MSME Act is to see that MSME, micro, small and medium enterprise, is not allowed to die. It is, if it fallen sick, protect it, nurse it, revive it. So therefore, till that is done, no form, and the banks are tasked with the responsibility of nursing and care, and if nursing and care is not possible, then it should be allowed to die. That recovery is certainly permitted. So that petition, then my contention was not accepted by the Bombay High Court. They said, yes, MSME Act is a preventive legislation, remedial legislation, benevolent legislation, everything is accepted, but it is confined to the banks and financial institutions and not beyond that. It does not cover cover the lease. So my convention is different. It covers everything: rent, lease, electricity charges, provident fund, ESI, every form of recovery. And that judgment I took in challenge before the Supreme Court, and fortunately the Supreme Court was pleased to admit the matter and stayed all further recovery proceedings. So that is something which is reassuring. But the Kerala High Court judgment, it took a narrow restrictive interpretation. So it's a fundamental principle of law that legislation which is preventive, remedial, benevolent, has to be given the widest possible interpretation. All that should the court be concerned is what was the legislative intention, and construction which will advance the legislative intention and suppress mischief, that has to be adopted. And the Kerala High Court unfortunately did not agree to that convention. And now and then Kerala High Court judgment contains another grave mistake also. See, I am open against, I even seen as a critic of the concept of precedent. Precedent is a wonderful principle. It's a useful tool. It's one of the important sources of law. But today, we said 77 lakhs of judgments. Precedent has been reduced to a level of absurdity. If 77 lakhs of judgment, and we have every judgment at least 20 pages, if you have to find out it from 15 to 20 crore pages of literature, the law of the land, then there is no law of the land. So a time has come then the legal fraternity and our judges, it's time that we have to think, take an introvert. Can we just blindly follow in the name of judgments to be cited? If you cite a judgment, a reason be given. I tell you the calamity which has been caused by the misinterpretation of the judgment in the Kotak Mahindra case. Kotak Mahindra case, the dispute between the Kotak Mahindra, who has lent money to a person whom the MSME also supplied goods, and he has given his property as a security to the bank. So the bank, it is a secured asset. For the supplier MSME, it is not a secured asset. But the MSME got a certificate from the award from the MSME council, and that award is executable like a decree, and it is executable as arrears of land revenue. So when it went on to execute it, then the question was between the MSME supplier, and he is obviously a creditor, and the bank financial creditor. Between the two creditors seeking to enforce their rights against the third person, whom the MSME has supplied goods and whom the bank has lent money, who has got a primacy. Then under the MSME Act, the MSME has a primacy. And that position is clear from the recent judgment of the Supreme Court. This is Bela Tiwari's judgment in Gujarat State Civil Supplies case. Yes. Now the question is, now this issue, the issue, the controversy there was between two suppliers, and the court decided in favor of the MSME, in favor of the bank only because of the section 26C, which was incorporated in 2016 by amendment. So SARFAESI Act was amended and said the section 26E was incorporated, and it said the claim of the banks will prevail over the taxes, government claims, everything. Therefore, the Kotak Mahindra case was decided in favor of the bank because of the amendment of section 26E, incorporation of section 26E. But the reliance on the Kotak Mahindra in our case has absolutely no relevance. It's an entirely different subject. The other was a dispute between two creditors. Here the dispute is between a creditor and a debtor. The MSME as a debtor and the bank as a creditor. So I am concluding it because maximum more than 10 minutes the video will not go. Thank you. Therefore, the judgment of the Kerala High Court is a great, it's a great error. To err is human. So it is a result of mechanically citing judgments without knowing what was decided. What was decided in the Kotak Mahindra was, to repeat, a dispute between two creditors against the debtor. Here the dispute, in our case, is the dispute between a bank as a creditor and my client and MSME as a borrower. Entirely two different subjects, absolutely nothing in common. Thank you.